Thank you, Irena. And I can only echo how important it is that I think we're having this conversation, and what an obvious place to start when we're talking about challenges to the rule of law in recent months. There have, as Irena has set out, been huge concerns about the government's plan to break international law in what now feels to be the quote that we'll all remember, in a specific and limited way. And it has huge ramifications in a whole range of ways for the UK's place in the world, for Brexit, the constitutional implications, some of which Irena has touched on. But I want to talk about some of the international law implications, and also briefly in terms of the implications on Northern Ireland. And the point that I want to make is that I think that the consequences of this, in terms of the international consequences, are much more than simple tut-tutting. And I also want to reject the proposition, which I have heard mentioned in the discussions around this bill, that states violate international law regularly, that somehow international law is of less effect or consequences than other types of law. It's not true. And also the nature of the proposal in this piece of legislation really is remarkable, because it's a preemptive breach. What's set out in the legislation is that it gives the government powers to violate the withdrawal agreement if they need it. They don't know that they need it. They're simply setting out their stall in advance, and that is what makes it absolutely remarkable, not least because there is provision within the withdrawal agreement to resolve any conflicts that arise. So I'm going to set out four main concerns, and let me tell you, it was quite a tough job to whittle them down to that. So the first one is about that I think it undermines, this act alone of laying this legislation before the Commons undermines the ability of the UK to negotiate treaties. And I'm talking beyond Brexit here. In the years to come, the UK is going to have to negotiate any number of treaties with any number of countries. How would you feel if you were sitting down opposite a government who, just a number of months after signing a treaty, decided, and indeed winning an election off the back of it, decided to pass domestic legislation undermining it? International law and treaties between nations are grounded on trust and confidence, and I think there is a real issue in treaty negotiation as a result of this act, whether political tactics or otherwise. It poses a real concern. Secondly, it undermines the country's ability to hold others to account when they violate international law. All you have to do is look at the Foreign and Commonwealth's Twitter page to see still that there are endless tweets about the government in a whole range of countries, the rule of law in Hong Kong, freedom of expression in Turkey, China, and that is all well and good, and indeed work that we support, and certainly in the Bar Human Rights Committee, which I'm involved in, work which we are always trying to promote. But it makes our job much more difficult, and it makes the Foreign Office jobs much more difficult. How can you go to another country and promote the rule of law and avoid them saying to you, well, you're telling us this, but you're doing something else yourself? How do you avoid the label of hypocrisy if you have laid a piece of legislation before the Commons, which, as Irena has set out, preemptively and very blatantly, in a barefaced way, proposes to violate international law? The third point is about a softer point, really, about the place in the world and also the legal system as a whole, because I think that our profession, solicitors, barristers, judges, mediators, do rely on the reputation that the legal system as a whole in this country is one which can be trusted, which is fair, has integrity. And I think that there's a risk of all of this seeping through and undermining that reputation. And it's a point made, I think, most effectively in a quite remarkable intervention by the Chief Justice of Northern Ireland, Sir Declan Morgan, who is the current Chief Justice, and who took it upon himself to give an interview when this piece of legislation was introduced, saying that it risks undermining trust in the rule of law and the administrative justice, and indeed in the legal profession. So I think there is a concern. I think the position of the law officers also raises a concern as to the approach to this bill. But I also think, on the other hand, we can take some comfort from just how the professions as a whole have responded. The resignations that Irena mentioned, the Bar Council and the Law Society have made very strong statements calling for the removal of these clauses. Lord Neuberger, who has contributed extensively to a number of IBA debates, which I know many of you will have seen. And there has been a unity in the profession across the board, and a real call that this is not a political issue, that this is not a Brexit issue, that this is a rule of law issue. And I think our role as lawyers is to make that point repeatedly. And I think issues surrounding the rule of law are issues for us. And so when we're thinking about the issue of how do we uphold the rule of law, I suppose one point that I would make would be to remind us all that we have a part to play in that. The fourth and final point that I want to make is about Northern Ireland, because we've talked about the international law issues that arise from the legislation or the bill even, but and the ways in which there is a proposal to breach international law. But what is also important is what is the apparent justification for this preemptive breach. And we are told eventually that the reason for it was, in fact, to protect the Good Friday Agreement and the Northern Ireland peace process, when in fact I think anyone would accept on a proper analysis that it is likely to have the opposite effect. And we remember, of course, that the Good Friday Agreement is also an international treaty, which the government is also bound by and in fact is a co-guarantor of. And it is using, in fact, this international treaty in quite a selective and partisan way to justify the breach of another international treaty. And the justification is a further compounding factor which should cause alarm in terms of the rule of law. And even setting aside the rule of law issues, it's an unfortunate decision to make, I think, going into a very sensitive time in the Brexit negotiations, particularly for Northern Ireland. And I really just want to end with some broader reflections, which Irena has also picked up on, that what we are seeing in recent months are, I think, more challenges to the rule of law. I think it's appropriate to draw parallels that this is happening in other countries too, in other European countries, and that it's very useful to make sure that we pause and really acknowledge the reality of that. I think what has been interesting in discussions about the Internal Markets Bill is there have been questions about, well, is this a once-off because of Brexit? Is this really just tactics, political negotiation tactics? Whether it is or not, I think probably Irena and I agree that it still poses a direct and very serious challenge to the rule of law. But also, and what I hope we can come to discuss throughout the evening event is that this does feed into a bigger picture about accountability and the separation of powers, about activist lawyers and enemies of the people, also about the way in which law and decisions are made, about consultation and about delegated legislation. In relation to this bill, of course, we heard about the specific and limited breach in Parliament long before we knew anything about the detail. And it may also represent a move away from an international legal order based on rules, or at the very least, I think that's a question that's worth raising. So really just to conclude, I would reiterate that this is not a specific and limited breach, however the government may wish to define it. It is huge and it has far-reaching consequences domestically, constitutionally, internationally, and for Northern Ireland. And I agree with Irena's analysis that it can be a very slippery slope once, particularly in this barefaced way, there is a proposal to breach the rule of law in this way. And I would conclude really just by saying that in looking at the question of how we uphold the rule of law, we as lawyers have a particular responsibility in that, and we can be proud of the way our community has responded so far and continue to make arguments about this bill and why it should not become an act with the controversial clauses remaining in it. So thank you very much.